Why you stand?
Most of the issues that we are considering is the competing arguments on the options available to the governor under Article 200 and 201. The submission made on behalf of the Union of India and of some of the states that have supported the reference is that the text of Article 200 is explicit. Upon presentation of the bill, the governor can assent to the bill. Upon presentation of the bill, the governor can assent to the bill, or he can withhold assent therefrom, or he can reserve the bill for the consideration of the president. The first proviso to Article 200 regarding return of a bill to the legislature according to this submission is an additional option available to the governor, making it a total 4 alternatives that the governor can choose from. Then they have placed reliance on the various judgments. In opposition, it has been argued that Article 200 provides the governor with 3 options only: assent to the bill, reserve it for consideration of the president, or return the bill with message to the House requesting it to reconsider the bill or a part of it. And after such reconsideration, if the House passes the bill, again with or without amendment, the governor is bound to give assent. And they have placed reliance on the various judgments, support of the state submission. The second interpretive choice on Article 200 is to bind the first proviso to the substantive part of Article 200, to qualify the power of the governor to withhold the bill, in which case the governor is provided with a total of 3 options between the substantive part of Article 200 and the first proviso thereto. First, the governor may assent to the bill. Second, he may reserve the bill for the consideration of the president. Third, he may withhold assent therefrom and return the bill to the legislature with comments. And if it is passed with or without amendment, he shall not withhold the assent therefrom. The third option, in such a reading of Article 200, can be exercised only if the bill is not a monetary bill. The substantive part of Article 200 employs 3 verbs that indicate the options of the governor: assent, withhold, and reserve. Each of these actions are qualitatively different from one another. However, the first proviso, which repeats the verb withhold, indicates that the word withholds in the substantive part is not without qualification. The first proviso, in our considered opinion, qualifies the verb withholds in the substantive part and obliges the governor to return the bill in accordance with the first proviso, except in case of a money bill. In that sense, the first proviso is not an exception that creates a fourth option. It is rather qualification to the substantive part of Article 200, limiting the full play of the word withhold employed therein. We are of the firm opinion that if 2 interpretations are possible, then an interpretation that favors a dialogic process that encourages the institutional committee and deliberations between the constitutional institutions, in this case, that of the governor and the House or the Houses, must be preferred over an interpretation that limits or eschews such a dialogue. Such an interpretation prevents institutional redundancy. Whatever the description of Indian federalism, we think that it would be against the principle of federalism and a derogation of the powers of the state legislature to permit the governor to withhold a bill without following the dialogic process in the first proviso to Article 200. In our opinion, the first proviso, initiating a constitutional conversation between the institution of the governor and the House or Houses, and the option to reserve the bill for the consideration of the president under the substantive part of Article 200, exemplify the cooperative spirit of Indian Constitution and also bring out different facets of the checks and balances model that the Constitution has envisaged. A dialogic process which has the potential to understand and reflect on conflicting or opposing perspectives, to reconcile and to move forward in a constructive manner is an equally potent check and balance system that the Constitution has prescribed. Once this perspective is grasped, the persons who occupy various constitutional offices or institutions will also do well to ingrain in themselves that dialogue, reconciliation, and balance, and not obstructionism is the essence of the constitutionalism that we practice in this republic. The next issue we are considering is whether the governor is bound by the aid and advice rendered by the Council of Ministers while exercising all the options available with him when a bill is presented before him under Article 200 of the Constitution. Before we opine on these aspects, on whether the governor is bound by the aid and advice of the Council of Ministers in exercise of his functions under Article 200, it is relevant to note the judgment of this court that were taken a view of the discretion of the governor and Article 200. Particularly, both sides rely on the same judgments but offer different reading or interpretations of them. Like Shamsher Singh versus State of Punjab, then MP Special Police Establishment versus State of MP, Nabam Rebia and Bakmang Felix versus Speaker, Deputy Speaker Arunachal Pradesh Assembly. We are of the opinion that from the above discussion, the following position of law clearly emerges. First, ordinarily the governor exercises his functions in accordance with the aid and advice tendered by the Council of Ministers. Secondly, the Constitution itself provides that the governor may discharge certain functions upon his discretion and without being bound by the aid and advice tendered by the Council of Ministers. Thirdly, the circumstances or occasions where the governor is to discharge his functions without being bound by the aid and advice of the Council of Ministers are either expressly provided or through necessary implication, where the constitutional context requires exercise of this discretion. In such a context, the role of the President in protecting and defending the Constitution is binding the Union as a cohesive unit is crucial. It is reiterated that the President will be unable to exercise his functions until the Governor a priori reserves a bill for his assent. It is unlikely that the Council of Ministers, without whose support the bill could not have been passed by the legislature, will advise the Governor to return a bill to the legislature or refer it to the President under Article 200, thus frustrating the operation of numerous provisions of this Constitution, including the President's powers. In such a scenario, it is unfathomable to hold that the Governor is not conferred with discretion under Article 200. We are also of the considered opinion that the inclusion of the phrase "in the opinion of the Governor" in the second proviso to Article 200 is but a definitive expression of the fact that Governor does enjoy his discretion in discharging his function under Article 200. Either the Governor enjoys discretion or he does not. There is no interpretive space for discretion while exercising some options of Article 200 and no discretion in others. A limited application of this phrase to only the second proviso is neither logical nor in accord with the constitutional scheme. We find it difficult to agree with the submissions canvassed by the party opposing the reference that a limited interpretation must be placed on the aforesaid phrase. This second proviso is clearly a qualification or a condition of, and not an exception to the exercise of discretion contemplated under substantive part of Article 200. We are conscious that a government run within the four corners of a written constitution must be responsible. Having already held that the Governor does not have powers simpliciter to withhold, we find that the Governor has discretion in the context of referring a bill for the consideration of the President or for returning the bill to the legislature with comments. We do not think that the interpretation confers any unfettered powers on the Governor. In fact, it does not in any way deviate from the concept of a responsible constitutional government. Much has been argued on the role of the Governor and the President and the Cabinet form of governance that parliamentary democracy consists of by parties opposing the referendum. They argue that this system of governance above conferral of discretion on the governor, where an agreement that it is the elected government, the cabinet, that should be in the driver's seat, and that there cannot be two executive powers centers in the state, as held in Ram Jawai Kapoor and others. However, we find that these arguments relating the governor and the president to a perfunctory role that is merely the formal head comparable to the crown in England oversimplifies the complex scheme of our written constitution. The constitutional vision is of a responsible government which is not merely synonymous with the cabinet, but is also one where the governors and the president have been bound by specific functions and roles in the written constitution, unlike the crown. To clarify, as we already held, that the governor has no option to withhold a bill simpliciter. Therefore, it is not that the discretion so conferred allows a situation wherein the governor could frustrate a bill in perpetuity. The three clear options that he has is to grant assent, withhold assent, and return the bill to the legislature for reconsideration, or reserve the bill for consideration of the president. And he can exercise the discretion in choosing any of these three options, having given due regard to the aid and advice rendered by the Council of Ministers, and keeping in mind his duty to protect and defend the Constitution. The next we consider questions number 5, 7, 10, and 11 relating to the discretion of time limits on the governor and the president for exercising their discretion under Article 200 and 201, and the issue of deemed assent. The text of Article 200 and 201 has been framed in such a manner so as to provide a sense of elasticity for constitutional authorities to perform their functions, keeping in mind the diverse contexts and situations, and by consequences, the need for balancing that might arise in the process of lawmaking in a federal and democratic country like ours. The imposition of timelines would be strictly contrary to this elasticity that the Constitution so carefully preserves. The concept of deemed assent in the context of Article 200 and 201 presupposes that one constitutional authority, herein the court, would play a substitutional role for another constitutional functionary, herein the governor or president. Such a usurpation of the gubernatorial powers, the functions of the governor, and similarly of the president's function, is antithetical not only to the spirit of the Constitution, but also specifically the doctrine of separation of powers, which is a part of the basic structure of the Indian Constitution. We have no hesitation in concluding that the concept of deemed assent of pending bills by the court in exercise of jurisdiction under Article 142 is virtually a takeover of the role and function of a separate constitutional authority. The reliance on Article 142 cannot lead to supplanting constitutional provisions itself. And the next issue is with regard to justiciability of the functions exercised by the governor and the president under Article 200 and Article 201, respectively. We have the considered opinion that the court in the state of Tamil Nadu was bound by the earlier decisions, and the discharge of functions by the governor and president under Article 200 and 201, respectively, is thus non-justiciable. The most drastic consequence of accepting that assent, reservation, or return can be challenged is that in any of the formulations of this court in the state of Tamil Nadu, it is not the enactment which will be brought for review of the court, but the bill which will be subjected to judicial review. In other words, to determine whether a bill has been correctly accorded assent or not, the primary document brought before the court's consideration will be the text of the bill anterior to the stage of becoming a law. The people's will expressed through legislative branch is only definitive and conclusive upon receiving the assent of the governor or president as the case may be. This is not an empty formality. It is only such a definitive expression of legislative will that is subject to judicial review. When Articles 13, 245 and 246 employ the word law, in all these cases, law means legislation that is enacted in accordance with the Constitution. In view of the above discussions, we find no reason to deviate from the binding decision of this court and for the additional reasoning stated above, or the considered view that the discharge of the governors or president's function under Article 200, 201 respectively is not justiciable. Further, we are of the firm view that the judicial review scrutiny and the jurisdiction of court can be invoked only once the bill becomes the law. It is unfathomable, keeping in mind the way in which we practice our constitutionalism in India, to suggest that the bills can be brought to court and adjudicated upon rather than opined upon under Article 143. The only limited scope and known constitutional route through which the judiciary can look into a bill is if the President, in exercise of Article 143, referred such a bill to the Supreme Court to opine on in discharge of advisory jurisdiction. It is also clarified that the President is not required to seek advice of this court by way of reference under Article 143 on every occasion that a bill is reserved for his consideration by the Governor under Article 200. The President's subjective satisfaction is sufficient under Article 201. If for any extraneous reasons the President so requires this court to tender an opinion on a bill or a specific aspect of it, a reference invoking an advisory jurisdiction under Article 143 always lies. Then we have considered the limits of judicial intervention. The courts cannot interfere in the procedure of a bill's passage and embark on its merit review, as already observed earlier in this opinion. However, the consequent question that arises, as it did before the court in the state of Tamil Nadu, is what redressal lies when no decision is forthcoming from the governor under Article 200. We have given the submissions on such a situation our anxious consideration. To permit a reading of the Constitution that enables or even allows unchecked discretion to potentially bring bills passed in furtherance of the people's will to a procedural impasse and frustrate lawmaking would be antithetical to the values and spirit of the Constitution. That the governor enjoys discretion under the various provisions is no longer res integra. However, the question we are confronted with is whether the constitutional breadth of the discretion extends to protect an indefinite or prolonged inaction of the governor under Article 200. We are of the considered opinion that while merits of action taken by the governor under Article 200 cannot be looked into by courts, inaction that is prolonged, unexplained, and indefinite will certainly invite limited judicial scrutiny. Each constitutional organ or authority cannot function by itself. The working of our constitutional scheme is premised on a constitutional authority who are each assigned specific but interdependent roles, performing their duties akin to clocks that keep a clock ticking. They depend on each other to keep the Constitution humming and thus working. They are also constitutionally obligated to offer checks and balances for the other. Such a constitutional scheme thus evolves in action. In other words, our constitutional scheme works only if it is worked. It is one thing to say that one constitutional organ will not substitute or supplant the wisdom of or role of another constitutional authority, but completely another to shy away from the checks and balances on the pretext when there is a deliberate inaction. The concept of accountability and checks and balances courses through the provisions of the Constitution. Thus, the legislature, which represents the people's will, is only effective if the governor acts under Article 200. This is not to say that the governor is merely a rubber stamp between a bill becoming an act. There is a value in his consideration, and thus choice exercised between the three options before him under Article 200. Thus, it is correct that the court cannot supplant the wisdom of the governor and enter a merit review of the decision so taken. However, where the governor chooses to not act under Article 200, resulting in a prolonged pendency in bills without initiating the dialogic process that the Constitution envisions, thus frustrating the outcome of the legislature's function and a constitutional court can exercise limited judicial review. Courts are empowered to grant a form of limited direction to the governor to take action. The court can, after being satisfied from a perusal of the record on what has transpired, can issue a limited direction to the governor to act under Article 200 within a reasonable time limit without making any observations on the merits of the exercise of discretion. It would thus serve the purpose of asking the governor to exercise his functions under Article 200 rather than substituting the rule. The complexity of the bill presented, emergent nature of the enactment, nature of consultative process undertaken are a few illustrative factors that the court will take into consideration while issuing limited mandamus to take an appropriate step under Article 200. We clarify that this does not extend to the court directing the one particular course of action will be employed by the governor. There is no formulaic manner or timeline that the courts by judicial order can establish. Not every case would lead to the court to issue an automatic direction to act. Rather, this limited direction would have to be measured based on appropriate circumstances. In this manner, limited discretion that the court can issue serves as a form of constitutional accountability. Then our answers to the reference. In the light of our findings and observations above, we deem it appropriate to summarize our conclusions on this presidential reference. The governor has three constitutional options before him under Article 200, namely to assent, reserve the bill for consideration of the president, or withhold assent and return the bill to the legislature with comments. The first proviso to Article 200 is bound to the substantive part of the provision and restricts the existing option rather than offering a fourth option. Pertinently, the third option, to withhold assent and return with comments, is only available to the governor when it is not a money bill. The governor enjoys discretion in choosing from these three constitutional options and is not bound by the aid and advice of the Council of Ministers while exercising his function under Article 200. The discharge of the governor's function under Article 200 is not justiciable. The court cannot enter into a merits review of the decision so taken. However, a glaring circumstance of inaction that is prolonged, unexplained, and indefinite, the court can issue a limited mandamus for the governor to discharge his function under Article 200 within a reasonable time period without making any observation on the merits of the exercise of the discretion. Article 361 of the Constitution is an absolute bar on judicial review in relation to personally subjecting the governor to judicial proceedings. However, it cannot be relied upon to negate the limited scope of judicial review, and this court is empowered to exercise in situations of prolonged inaction by the governor under Article 200. It is clarified that while the governor continues to enjoy personal immunity, the constitutional office of the governor is subject to the jurisdiction of this court. In the absence of constitutionally prescribed time limits and the manner of exercise of power by the governor, it will not be appropriate for this court to judicially prescribe timelines for the exercise of powers under Article 200. For a similar reasoning, as held with respect to the governor, the President's assent under Article 201 is not justiciable. For the same reasons as indicated in the context of the governor under Article 200, it is clarified that the President too cannot be bound by judicially prescribed timelines in the discharge of functions under Article 201. In our constitutional scheme, the President is not required to seek advice of this court by way of reference under Article 143 every time a governor resolves a bill for the President's assent. The subjective satisfaction of the President is sufficient. If there is a lack of clarity or the President so requires advice of this court on a bill, it may be referred under Article 143 as it has been done on numerous previous occasions. The decisions of the governors and the President under Article 200 and 201 respectively are not justiciable at a stage anterior into the law coming into force. It is impermissible for the court to undertake judicial adjudication or the contents of the will in any manner before it becomes a law. Particularly, the discharge of its role under Article 143 does not constitute judicial adjudication. The exercise of constitutional powers and the orders of the President and Governor cannot be substituted in any manner under Article 142. And we hereby clarify that the Constitution, specifically Article 142, even does not allow the concept of deemed assent of bills. Question 11 is answered in accordance with our opinion tendered on question 10. That is, there is no question of a law made by the state legislature coming into force without assent of the governor under Article 200. The governor's legislative role under Article 200 cannot be supplanted by another constitutional authority. We already indicated in our opinion that question 12 relating to the Article 145(3) and the composition of benches in this court, that here cases of constitutional importance is irrelevant to the functional nature of this reference and is returned unanswered. We also indicated in our opinion that question 13 concerning the power under Article 142 is overly broad and not possible to be answered in a definite manner. Our opinion on the scope of Article 142 in the context of the function of the governor and president has already been answered as a part of question 10. Question 14 pertaining to this court's jurisdiction to resolve dispute between the union and state government outside of Article 143 is also found to be irrelevant to the functional nature of the reference and hence returned unanswered. We are grateful to all of you for your valuable assistance.
Lords, on behalf of the Honorable President of India and on our behalf, we express, my Lord, a sincere gratitude for a very illuminating opinion of your Lordship.
And I am extremely grateful to all my learned brothers who have, each of us have contributed. But one of us has contributed largely. On principle, we have decided that it will be go in the name of the court.
Well, I endorse what the learned solicitors mentioned, Malas, about the fact that we are grateful to your lordships for having given this very, very circumspect and thoughtful decision. We deeply obliged.
Grateful to your Lordship.
And that it is unanimous, Malas, even
Yes.
makes us happier.
Unanimous in one voice.
Yes, that makes us very happy.
I wanted it to be a voice of the court.
Yes,
Yes,
absolutely.
God speaks through
Absolutely.
one voice, my Lord. That's the
It's a rarity,
Healthy.
but it's great.
It's in effect sacrificed by one of us.
yeah, I understand, my Lord. That's by each one of your Lordship. My Lord.
Deeply obliged.
Obliged to.
Grateful. Grateful.